This pisses me off when it comes down to the trial even became a trial. This arrest was, in my opinion, 100% a pissed off the police arrest, P.O.P. arrest. Did I say there was 3? I'm sure there's other types, I just can't think about it right now. So yesterday I lost a resisting without violence jury trial. It was a 2-day trial. I have to say, I'm not upset with my performance. I'm not upset with the client's decision to go to trial. It was based upon principle, but I am upset we lost. No doubt about that. End result, not horrible, not the best, but not horrible, and well within the expectations when we made the decision to go to trial. Let's go back. So I was a military police, airborne military police officer based out of Fort Bragg. One of the things that I was taught there was that, I don't know where it was in my training, but it was relatively early on, was if you're going to interact with someone, you're going to write someone a ticket for speeding or for running a red light, you make your decision whether you're going to write that person a ticket for that offense before you get out of the car. And that way you know that there is no bias and that their attitude isn't affecting you, it's their individual action. And I think that's the crystal clear way that it should be done in a perfect world. I think that's an ideal circumstance. Now, did I always follow that? I tried to, probably 100% or 80% more than most officers do, because I don't think that's trained anywhere. I don't think most officers even consider that. But I've never arrested somebody simply because they pissed me off or they had an attitude. That's not to say I haven't written a couple extra tickets to somebody who has pissed me off. So I'm not trying to put myself out there that I was this perfect officer, didn't do anything wrong. But for the most part, I tried to avoid it, and I did a pretty good job of that. But let's talk about the pissed off police arrest. So one form of it is you have chicken shit grounds to take somebody to jail over. And you technically have a violation of law, but you definitely wouldn't be doing that in any other circumstance. That may be like the jaywalking charge and you get a chance to take somebody to jail, or I don't want to say panhandling because panhandling becomes a problem sometimes, so you have to. But anyways, there's different types of charges. You can just kind of push the envelope and it's an arrestable offense, but you typically wouldn't do it. And that's what a true pissed off the police charge is. That you're in a circumstance that you normally would let go, wouldn't even bat an eye at, or maybe threaten arrest, maybe cuff somebody for a few minutes, get them to calm down, change the circumstance, and then you're going to let them go. But the other form of piss off the police type of arrest is a little bit different and not as egregious. This is the person you're already going to take to jail, and now you, in some circumstances, if they're cooperative, then you give them a lesser charge. If they're cooperative, you don't violate their probation that night. So there's things that you do have some flexibility with that you can leverage cooperation with the officer or with the person that you're arresting to ease their situation a little bit, and now they're not a pain in the ass for you. The V.O.P., that's a big one, that they don't violate the probation, they'll let that happen down the road, because if you violate the probation, it's a no bond status, and then you're putting their life into a tailspin because they're going to be in jail with no bond for probably a week or two before they can get a bond, if they can get a bond. Now, some cops, they don't take that into consideration, and if you got the charge, black and white, they're going to add it on there. Were there situations that I look back to and say I shouldn't have arrested this person? I mean, I arrested, I don't know, maybe 1,000, well over 1,000 people, I guess. Yeah, 2 come to mind. One, I can't even think of who it is right now, but I know there's 2 that I look back on and say it wasn't right. But the standard for arrest is probable cause. That's a low standard. And when I made the arrest, I was confident in what happened. I knew I had probable cause to arrest them. But then the next day or hours later, I recognized, I do not remember the exact circumstances, but I recognized, the way I saw that roadside isn't the way that it went down. And I then sent an email through the system, and I got in touch with the prosecutor to get the case dropped within a day or 2. So the person had to go through a hardship, but the end result for them was Look, they were in a questionable circumstance. The police officer, me, decided to arrest them for that questionable circumstance. So they went to jail and then got out an hour, 2 hours later, and then the charges were dismissed shortly thereafter. So they lost a couple $100 for being in a questionable circumstance. Not great. I understand. I don't want to put people, I didn't want to do that, but the end result isn't too bad. So one of the problems that I had in this trial was that I was surrounded. Technically, the facts were there. There is a technical resisting in this particular case. But it's such a minor resisting that it should be overlooked literally like that, no problems at all. But I can't argue jury nullification. So the elements I have to argue and what I have to argue, I can't argue to the jury that it is a bullshit arrest. I mean, I can present evidence and try to get them there and understand that. And I think they did understand that. But I can't argue that they did not follow the law. That's called jury nullification. And to not be able to argue jury nullification in a P.O.P. arrest is insane. You know, there's a lot of eyes on this case. A lot of attorneys, a lot of cops, and I imagine many people. There's a lot of eyes on this case here. I'm not going to go into the details why, but anyways, a lot of eyes. There's a lot of questions probably being murmured. Why did we go to trial? Why did you fight it? Why not just working out with a plea? The facts were against us. We knew that. We knew that by definition, they could probably establish that. We had a lot of fight back, and there's a lot of conflicting evidence, don't get me wrong, but we knew that this was an uphill battle, for sure. But I'm not scared of that. I'm not afraid to fight uphill battles. I was in the military, and we trained for war. My military mission as a military police officer was MSR control for the most part. The main supply routes that go from in the rear where the gear people are to the front lines. I wasn't a front lines guy. That was what we trained for, was to be on the roadways between the front lines and the end to help direct traffic, because the infantry don't know where the hell they're going. Just a ball bust there. Nothing against the infantry. You guys are awesome. But gotta bust your balls. The point is, having 360 security and knowing what's going on around me and ready to fight that's what I did. That's fine with me. I'll go to court when everybody's against me. I don't give a damn. Let's fight. Let's do this. If I got a client ready to go, let's do it. Especially in a situation that I think is total bullshit. On something like this should have been caught. One, the arrest should have never taken place. Two, if it was taking place, it should have been dropped during intake. It wasn't dropped during intake. It should have been dropped by the prosecutor. It wasn't dropped by the prosecutor. Then we have the judge. Try to get it dismissed by the judge. He couldn't get there procedurally. Then the next step, the final step. That's where we're at here. Is the final step is the jury. And now we got to rely on the jury to do the right thing and get rid of this charge that should have never been arrested in the first place. The problem is the jury is specifically instructed you are to follow the law, and the law is outlined in these 10 pages we're going to send back to you. And you cannot make a decision, or if the person has satisfied this requirement, this requirement, and this requirement, then she is guilty or he is guilty. And they can't deviate if they're going to follow the law and this, and this are satisfied, they have to find guilt. They can't say, although this, and this happened, it shouldn't have happened. That's the jury nullification argument. Have weed in my pocket, but I don't like weed, or I don't care, I don't think weed should be illegal, so therefore I'm going to say not guilty. That would be an illegal act by the jury. So, and juries do it all the time, but it's an uphill battle because you have to get them to, you can't argue. You can't argue. So it has to be essentially something they draw the conclusion on their own. That's where we sit. If you're a defense attorney and you want help on this and you're here in Central Florida, let's talk about it. Let's figure out if I can do something to help out there. Anyways, subscribe to the channel, like the video, add your comments down below.